Never sign this bank document without reading page 3. Here is why. There is a document your bank puts in front of you every time you open an account, upgrade a service, or accept a new product. And buried inside that document, almost always on or near page 3, is a clause that most seniors sign away without reading. A clause that determines whether you can sue your bank in court, whether you can join a class action lawsuit with other customers who were harmed the same way you were, and whether any dispute you ever have with that institution will be decided by a private arbitrator the bank itself helped select, rather than by a judge or jury of your peers. That clause is called a mandatory arbitration agreement. And once you sign it, which most people do because it is buried inside a document presented at a moment when you are focused on opening the account, not reading the fine print, you have permanently waived your right to take your bank to court for virtually any reason. Not temporarily, not conditionally, permanently, for as long as you hold that account. The Consumer Financial Protection Bureau found that most consumers who sign these agreements have no idea they exist. Your bank is counting on that. If this is your first time on this channel, subscribe right now. Professor Kyle Pomerlow covers the banking rules, tax laws, and consumer protection statutes that directly affect seniors and retirees every single week. Free, plain English, no product to sell. Hit subscribe so you never walk into a bank without knowing exactly what you are signing. Before I go further, I need to address two groups of people who are already thinking this does not apply to them. And both of them are wrong. The first group is the senior who has banked at the same institution for 20 or 30 years and has not signed a new account document in decades. They are thinking this is a problem for people who recently opened accounts. That is incorrect. Most major banks updated their account agreements between 2017 and 2022 to include or strengthen mandatory arbitration clauses. And they delivered those updates through a notice inserted inside a monthly statement or mailed as a standalone document that most customers discarded without reading. If your bank updated its terms in the past 7 years and you continued using the account without objecting in writing within the specified window, you accepted the new terms by conduct. You are already bound. The second group is the senior who is thinking that arbitration cannot be that bad, that it is simply an alternative dispute process, and that if the bank did something wrong, arbitration would still make it right. That belief is not supported by the data. The Consumer Financial Protection Bureau analyzed thousands of arbitration cases involving financial institutions and found that consumers received zero relief in the overwhelming majority of cases, while banks used the same arbitration firms repeatedly and won at dramatically higher rates than consumers did. Arbitration is not a neutral alternative to court. It is a system that structurally favors the institution that uses it hundreds of times per year over the individual who uses it once. I am going to cover what is actually on page 3 of these documents, what it means for you legally, and exactly what you can do about it, both for accounts you already hold and for any account you are considering opening. Both groups have options. Stay with me. So, why do banks include mandatory arbitration clauses in their account agreements? The mechanism is straightforward, and the financial incentive is enormous. A class action lawsuit allows thousands of customers who are harmed by the same banking practice to pool their claims into a single case. The aggregate damages in a class action can reach tens of millions of dollars, enough to force a bank to change its practices and compensate every affected customer. A mandatory arbitration clause eliminates class actions entirely. Each customer must bring their individual claims separately. A customer harmed by an illegal $15 monthly fee is not going to file a solo arbitration case over $15. The cost of filing exceeds the recovery. The bank keeps the money from every customer who signed the arbitration agreement and does not pursue an individual claim. The CFPB estimated that mandatory arbitration clauses allowed financial institutions to retain billions of dollars in fees and damages that would otherwise have been returned to consumers through class action settlements. In 2017, the CFPB passed a rule prohibiting mandatory arbitration clauses in consumer financial contracts. That rule was overturned by Congress 4 months later. The clauses are currently legal and in use at virtually every major financial institution in the United States. Your bank did not put this clause in your account agreement by accident. It put it there because it saves the institution significant money every year. Money that comes directly from customers who signed without reading page 3. My name is Professor Kyle Pomerlow. I have spent decades studying federal consumer protection law and the specific mechanisms that financial institutions use to limit their legal exposure to the customers they serve, particularly senior customers who are more likely to hold long-term accounts, less likely to switch institutions, and statistically less likely to read and challenge the fine print in account agreement updates. The situation I find most troubling is not the senior who was defrauded in an obvious scheme. It is the senior who was charged an illegal fee, or had their account mismanaged, or was sold a product that was misrepresented, who had a completely legitimate legal claim against their bank, and who discovered only after the fact that they had signed away their right to pursue that claim in court years earlier without knowing what they were signing. The arbitration agreement does not prevent you from having rights. It prevents you from enforcing them effectively, and it was placed in your account document specifically to create that outcome. Here is exactly what we are covering in the next 20 minutes. I am going to walk through the 5 most consequential clauses found on or near page 3 of standard bank account agreements, what each clause says, what it means for your legal rights, and what you can do about it before you sign or after you have already signed. Then I am going to add 2 bonus points covering the specific language you can use to negotiate or reject individual clauses at account opening, and the one type of banking relationship where these clauses are significantly less common and where seniors have meaningfully stronger consumer protections. Everything I cover is based on federal consumer protection law and publicly available regulatory guidance. Sluice 1. The Mandatory Arbitration Agreement. Step A. Bust the misconception. The most common misconception about mandatory arbitration agreements is that they are negotiated case by case, that arbitration is simply a faster, cheaper alternative to court that works equally well for both parties. Neither of those things is true. Mandatory arbitration agreements in bank account documents are non-negotiable standard terms presented on a take-it-or-leave-it basis, and the arbitration process they create is not neutral. Banks appear before the same arbitration firms repeatedly, sometimes hundreds of times per year, while individual consumers appear once. The repeat player advantage documented by academic research consistently produces outcomes that favor the institution over the individual. Step B. The actual rule in plain English. A mandatory arbitration clause typically appears under a heading such as dispute resolution, arbitration agreement, or legal disputes. The core language states that any dispute between you and the bank, including disputes about fees, account terms, product representations, and the interpretation of the agreement itself, must be resolved through binding arbitration rather than through the court system. Binding means the arbitrator's decision is final. You cannot appeal to a court if the arbitrator rules against you, except in extremely narrow circumstances involving arbitrator fraud or misconduct. The class action waiver is typically a separate sentence within the same clause or an adjacent clause. It states that you waive your right to participate in any class action lawsuit or class-wide arbitration against the bank. This is the provision that prevents you from joining with other customers who experienced the same harm. Step C. Dual group delivery. For the lower income senior whose primary concern is fee disputes and account access, the arbitration clause matters most when your bank charges you an improper fee and refuses to reverse it. Without the arbitration clause, a pattern of improper fees affecting thousands of customers creates a class action exposure that motivates banks to settle and change their practices. With the arbitration clause, you must pursue your $15 fee individually, a practical impossibility, and the bank faces no aggregate liability for the same practice applied to millions of accounts. For the comfortable retiree with significant assets at a single institution, the arbitration clause matters most in disputes involving investment products, account mismanagement, or significant dollar amounts. A retiree who was sold an unsuitable annuity, who had funds moved without authorization, or who suffered losses due to bank error is precisely the customer for whom the right to a jury trial is most valuable, and precisely the customer whose arbitration agreement was most carefully designed to eliminate that right. Step D. The catch. Many arbitration agreements include a provision allowing you to opt out within a specified window, typically 30 to 60 days after account opening or after receiving notice of a terms update. This opt-out provision is almost never mentioned by bank staff and is buried in the same document as the arbitration clause itself. A senior who reads page 3 at account opening finds the opt-out provision and submits the required written opt-out within the specified window is not bound by the arbitration clause and can retain their right to court access for the life of the account. Step E. One action right now. Locate your current account agreement, available on your bank's website under Legal Documents or Account Agreements. Search the document for the words arbitration and opt-out. If an opt-out provision exists and the opt-out window has not closed, submit your written opt-out immediately via certified mail to the address specified in the agreement. Keep the certified mail receipt. If the opt-out window has passed, note the existence of the clause for any future account opening and read page 3 before you sign anything new. CLS 2, the Unilateral Amendment Clause. Step A. Bust the misconception. Most seniors believe that the terms of their bank account, the fee schedule, the interest rate, the features of the account, are fixed at account opening and can only change if they agree to new terms. That belief is incorrect for virtually every bank account in the United States. The Unilateral Amendment Clause, which appears in nearly every bank account agreement, gives the institution the right to change any term of the agreement at any time with as little as 30 days written notice. And your continued use of the account after the notice period constitutes your acceptance of the new terms. Step B. The actual rule in plain English. The Unilateral Amendment Clause typically appears under a heading such as Changes to this agreement or Our right to change terms. The language states that the bank reserves the right to add, change, or delete any provision of this agreement at any time by providing you advance notice as required by applicable law. The notice requirement under Federal Regulation DD for deposit accounts is generally 30 days for changes that are adverse to the consumer. The 30-day notice can be delivered by mail, by a message inside your monthly statement, by email if you have enrolled in electronic communications, or in some cases by posting the updated agreement on the bank's website. A notice delivered inside a paper statement, which most seniors process quickly and discard, satisfies the legal requirement regardless of whether you read it. Step C. Dual group delivery. For the lower income senior on a fixed income, the Unilateral Amendment Clause is most likely to affect you through fee increases and minimum balance changes. A monthly maintenance fee that was $0 when you open the account can be increased to $12 per month through a notice you may not have read, and your continued use of the account accepts the increase. The protection is reading every insert that arrives with your monthly statement, regardless of how routine it appears. For the comfortable retiree, the Unilateral Amendment Clause is most likely to affect you through changes to interest rates on savings products, changes to overdraft policies, and changes to the arbitration agreement itself. A bank that did not have a mandatory arbitration clause when you opened your account may have added one through a unilateral amendment, and your continued use of the account after the 30-day notice period accepted it. Step D. The catch. The Unilateral Amendment Clause cannot be used to change terms in ways that violate federal consumer protection law, but it can be used to change virtually everything else. And because acceptance is established by continued account use rather than affirmative signature, most customers never know a material term has changed until they try to exercise a right that no longer exists. Step E. One action right now. Set a recurring reminder every 6 months to download and review your current account agreement from your bank's website. Compare it to the version you reviewed previously and look for changes to the fee schedule, the arbitration clause, and the minimum balance requirements. This review takes 15 minutes and is the only reliable way to know what terms currently govern your account. Clue 3. The right of set-off. Step A. Bust the misconception. Most seniors have never heard of the right of set-off, which is precisely why it is so consequential when it is exercised. The misconception is that money in your bank account is entirely yours to control, and that the bank cannot touch it without your permission. The right of set-off means that in specific circumstances, your bank can apply funds from your deposit account directly against a debt you owe the same institution, without notifying you in advance and without your authorization. Step B. The actual rule in plain English. The right of set-off clause, typically found under a heading such as security interest or set-off rights, states that if you owe money to the bank and you are in default, the bank has the right to apply funds from any deposit account you hold at the institution against that debt. The debt can be a credit card balance, a personal loan, a home equity line, or any other credit product the bank holds. The set-off can occur without advance notice. Federal law provides one significant protection. Social Security and certain other federal benefit payments deposited directly into a bank account are protected from set-off for 2 months after deposit. Beyond that 2-month window, even Social Security funds can be subject to set-off in some states. Step C. Dual group delivery. For the lower-income senior, whose primary income is Social Security, the 2-month federal protection is your most important safeguard. Keep your Social Security direct deposit in an account at an institution where you carry no debt, no credit card, no loan, no line of credit. When your deposit account and your debt accounts are at the same institution, the right of set-off creates a legal mechanism for the bank to access your Social Security funds after the 2-month protection window. For the comfortable retiree with both deposit accounts and credit products at the same institution, the right of set-off exposure is proportional to your credit balances. A retiree who carries a credit card balance and a home equity line at the same bank where their primary checking account is held has created a set-off exposure that could result in significant account funds being applied against those debts in the event of a missed payment or default. Step D. The catch. Banks rarely exercise the right of set-off against customers in good standing, but the clause is enforceable and has been used against seniors who experienced unexpected financial difficulties. The protection is structural. Keep your primary deposit accounts at a different institution from any credit products you carry. Step E. One action right now. Review your current bank relationships. If your primary checking or savings account is at the same institution as a credit card, personal loan, or home equity product, consider moving your deposit accounts to a separate institution. The inconvenience of managing accounts at 2 institutions is significantly smaller than the risk of a set-off event during a period of financial stress. SKU S4, the electronic communications consent. Step A, bust the misconception. Most seniors who enroll in online banking or mobile banking believe they are simply gaining convenient access to their account information. They are also, in most cases, simultaneously consenting to receive all legal notices, including notices of material changes to their account agreement, electronically rather than by mail. The misconception is that electronic consent is limited to account access. In most account agreements, it is not. It extends to all legal communications the bank is required to send you. Step B, the actual rule in plain English. The Electronic Communications Clause, typically found under e-signed consent or electronic delivery of notices, states that by enrolling in electronic banking services, you consent to receive all disclosures, notices, and account agreement changes electronically rather than by mail. This means that a notice of a fee increase, a new arbitration clause, or a change to your account terms may be delivered to you as an email you may not open, a notification inside your online banking portal you may not see, or a posting on the bank's website that satisfies the legal notice requirement without you ever reading it. Step C, dual group delivery. For both groups equally, the electronic communications consent affects every subsequent notice the bank is required to send you. If you have enrolled in electronic banking and you do not regularly check your email from your bank, review your online banking notification center, and download updated account agreements when they are posted, you are effectively receiving no advance notice of material changes to your account terms, while the bank is in full legal compliance with its disclosure obligations. Step E, one action right now. Log into your online banking portal and navigate to the Notifications or Communication settings. Identify which categories of communication are set to electronic delivery only. For account agreement changes and legal notices specifically, request that these be delivered by mail in addition to electronic delivery. Most banks will accommodate this request. If the bank will not accommodate it, create a recurring monthly calendar reminder to check your online banking notification center for account agreement updates. CLS 5, the Dormancy and Escheatment provision. Step A, bust the misconception. Most seniors are not aware that a bank account with no customer-initiated transaction activity for a period specified in the account agreement, typically between 1 and 5 years depending on state law, can be classified as dormant and eventually escheated to the state. Escheatment means the funds are transferred to the state government as unclaimed property. The misconception is that this only happens to abandoned accounts that truly have no owner. It can happen to an account belonging to a perfectly attentive senior whose only account activity is automatic deposits and automatic bill payments, with no manual transaction initiated by the customer. Step B, the actual rule in plain English. The dormancy clause defines what constitutes account activity for purposes of the dormancy period. At many institutions, automatic deposits and automatic payments do not reset the dormancy clock. Only a customer-initiated transaction, such as a manual deposit, withdrawal, transfer, or login to online banking, resets the period. A senior whose Social Security deposits automatically and whose bills pay automatically, but who does not manually log in or initiate a transaction, may find their account classified as dormant and eventually transferred to the state despite regular financial activity flowing through it. Step C, dual group delivery. For both groups, initiate at least one manual transaction per quarter on every account you hold. A small transfer, a manual login with a transaction, a withdrawal. This resets the dormancy clock at virtually every institution, regardless of how dormancy is defined in the account agreement. Calendar a quarterly reminder for this purpose. Step E, one action right now. Search your account agreement for the words dormant, dormancy, and escheat. Identify the dormancy period and the definition of qualifying activity. If automatic deposits and payments do not qualify as customer-initiated activity under your agreement, set a quarterly calendar reminder to initiate a manual transaction on every account you hold. Everything I just covered gives you the knowledge to read and respond to the 5 most consequential clauses in your bank account agreement. What I am about to add is for the senior who wants to go further, either by negotiating specific clauses at account opening or by finding a banking relationship where these clauses are significantly less common. Bonus 1. What you can actually negotiate at account opening. Most seniors assume bank account terms are entirely non-negotiable. For standard consumer accounts at large national banks, that assumption is largely correct. The terms are standardized, and the institution will not modify them for an individual customer. However, 2 specific provisions are worth attempting to negotiate at any institution. The first is the arbitration opt-out. As covered in point 1, most arbitration agreements include a written opt-out provision within a specified window. This is not a negotiation. It is a right already built into the agreement that you must affirmatively exercise. Request a copy of the complete account agreement before you sign anything. Find the opt-out provision. Ask the bank representative to confirm the opt-out address and the deadline. Then exercise the opt-out in writing via certified mail within the required window. Keep the receipt. The second is the electronic communications consent. At many institutions, particularly community banks and credit unions, you can request that legal notices and account agreement changes be delivered by mail rather than electronically. Make this request in writing at account opening and ask that the written confirmation of your request be noted in your account file. At credit unions specifically, which are member-owned cooperative financial institutions rather than for-profit corporations, mandatory arbitration clauses are significantly less common. Class action waivers are less frequently used, and consumer protection practices are generally more favorable to account holders. If you are considering opening a new account, a federally insured credit union is worth evaluating as an alternative to a national bank for exactly these reasons. Bonus 2. How to file a complaint that creates a regulatory record. If your bank has applied a clause in your account agreement in a way that you believe violates federal consumer protection law, exercising set-off against protected Social Security funds, failing to provide compliant advance notice of a material terms change, or misrepresenting the scope of an electronic communications consent, You have two regulatory complaint channels that create a formal record. The Consumer Financial Protection Bureau complaint process at consumerfinance.gov requires the bank to respond within 15 days and resolve within 60 days. The response is logged in a public database that affects the institution's regulatory compliance record. Banks respond to CFPB complaints with significantly more seriousness than to customer service calls because the complaint creates documented regulatory exposure. The Office of the Comptroller of the Currency, the primary federal regulator for national banks, maintains a separate complaint process at helpwithmybank.gov. For state-chartered banks, the relevant regulator is your state banking department. Filing with both the CFPB and the relevant bank regulator simultaneously maximizes the institutional response. Let me bring everything together with the single most important idea from everything we covered today. Your bank account agreement is a legal contract. Every clause in it was drafted by attorneys whose job was to protect the institution's interests. The arbitration clause protects the bank from class action exposure. The unilateral amendment clause protects the bank's right to change terms without your affirmative consent. The right of set-off protects the bank's ability to collect debts directly from your deposits. The electronic communications consent protects the bank's ability to deliver legal notices in formats you may not see. The Dormancy clause protects the bank's ability to classify your account as abandoned if you do not engage with it on the institution's terms. None of these clauses are illegal. They are all disclosed, buried in a document presented at a moment when you are focused on opening an account, not reading fine print. The bank is counting on that moment. Page 3 is where the legal terms that matter most tend to concentrate, and it is the page that most people never reach. Professor Kyle Parmalo's message for this channel has always been the same. The institutions that hold your money are not your adversaries, but they are not your advocates either. They are businesses operating in their own interest. Understanding what you have signed is the only way to ensure that your interests are protected. Read page 3. Exercise the opt-out. Separate your deposit accounts from your credit products. Initiate a manual transaction every quarter. 4 actions that cost you nothing and protect rights that took decades of consumer advocacy to establish. Before you close this video, do one thing. Send this to one person in your life who is over 65 and has a bank account, which is everyone you know. A parent, a sibling, a neighbor, a friend from church. The document we discussed today is sitting in every one of their account files right now. Most of them have never read past page 1. The arbitration clause, the set-off provision, the dormancy rules, all of it is already signed. But the opt-out window may still be open. The quarterly transaction habit can start today. The complaint process is available right now. One conversation started by this video could restore legal rights that someone you care about signed away without knowing it. That is worth more than almost any other gift you could give them. That is what this channel is here to do. In the next video, I am going to show you the Social Security back payment that the SSA is holding for seniors who did not claim their benefits at the optimal time. A lump sum that can reach tens of thousands of dollars, and that the agency will not mention unless you ask the exact right question. I will see you there.